Today we have Andy Izenson, the Senior Legal Director at Chosen Family Law Center in New York. They primarily specialize in alternative family law and creation, gender and sexuality, and restorative and transformative justice. Andy is a part of the Family Law Institute of the National LGBT Bar Association and is an active member of the Family and Matrimonial Law Committee of the LGBT Bar Association of Greater New York. Andy is truly an amazing part of the LGBTQ plus community who uses all of their superpowers for good.
Hi, everybody. My name is Andy Izenson. I'm very happy to be speaking to you about this stuff today. This is one of the things I love to talk about, and I'm so grateful to Erin for calling me up. Um, so the first thing that I want to let you know is that when we talk about the law, a lot of people use the law as an analog for things like justice and morality and what should be the case, and lay those things on each other one to one. And I want to caution you as we go into talking about employment discrimination protections that that's an illusion. It's not actually true for anyone, much less for people who live in ways that are different from how the hegemonic norm is imposes upon us. The reason that I say this is because I would really love to be able to tell you, of course, no one can fire you for being a member of the LGBT communities. Of course, no one can fire you in a discriminatory manner. And if they did, then you have legal recourse for sure. I wish I could tell you that. It's actually a lot more complicated than that. I'm going to talk you through it. But I want you to know that when I say that the legal situation is complicated, it doesn't mean that it's ethically complicated. It doesn't mean that if somebody mistreats you at work or says things to you at work or passes you up for positive employment considerations or gives you negative ones, it doesn't mean that those things are okay. Um, they might be legal, but they're not okay. So the law, as I understand it, is a tool that we can use to protect ourselves against law. It's not an arbiter of what's right. It's not a benchmark of what should be the case. It's just a tool. So there are some employment protections in the law. Um, Employment protections here meaning if you face what's called negative employment consequences, which could be being fired, it could be being passed up for a promotion, it could be having uh, lower pay than your colleagues, anything like that. If you have employment consequences like that as a result of your sexual orientation, your gender identity, or a number of other protected characteristics, um, hypothetically, you would be able to sue under these laws and receive a settlement or be reinstated. The recent updates in the law are about taking the existing legal protections that exist for example, women, for example, marginal members of marginalized racial and ethnic groups, and extending those protections to also cover, for example, gay and trans people. So, in the same way as hypothetically there are legal protections against being fired because you are a woman, for example, or because you are a person of the ethnicity that you are or the race that you are, these recent legal extensions are intended to protect people from being fired because they are trans or because they are gay, bisexual, etc. So employment protections come from a couple of different places. One place that they come from is the states. This is the most unpredictable one because every state does everything differently. Each state has its own set of civil rights laws. A lot of the time, individual localities, towns, cities have their own civil rights laws, and some are more progressive than others. This is one of the places where when you're looking at employment opportunities, you're looking at jobs, a lot of what you're looking at is location and the legal landscape in the location that you're looking at. We're going to talk more about this later. At the moment, there are 23 states, as well as DC and Puerto Rico, and 400 individual cities and counties have enacted specific bans on discrimination based on both gender identity and sexual orientation in employment or in employment and other things like employment and housing. And 10 other states have some kind of ban on discrimination based on one or the other, either gender identity or sexual orientation, but not both. There are lots of resources that you can use to find out what anti-discrimination provisions exist in the localities that you're looking at. Usually just Googling the name of the state or the name of the locality and anti-discrimination provision is, or anti-discrimination law is going to do it. That stuff's on Wikipedia. It's not hard to find. Then there are the federal protections. So the big name in federal employment protections is Title VII. This is Title VII of the Civil Rights Act. It prohibits discrimination by employers who are covered under Title VII on the basis of the protected characteristics that are listed in Title VII. So at the moment, that's race, color, religion, sex, and national origin. So Title VII prevents or purports to prevent employers from inflicting negative consequences like firing or other things on you, on plaintiffs based on that list of protected characteristics: race, color, religion, sex, and national origin. The other big name in federal employment discrimination protections is the EEOC, the Equal Employment Opportunity Commission. The EEOC is the enforcement arm of Title VII. It's how Title VII works. The EEOC can do two types of things. An individual, if they believe they have been discriminated against, can sue under the EEOC, or the EEOC can by itself identify discrimination and bring a suit about it itself without having an individual plaintiff ask. So the EEOC enforces the terms of Title VII. So at the moment, it's not in the black letter law that the EEOC, black letter law here means the law that's written down. It's not in the written down law that the EEOC is there to protect people from discrimination on the basis of sexual orientation or gender identity. However, in recent years, the EEOC has been autonomously expanding the range of its purview to, in some cases, include those things. We're going to talk a little more about that in a moment. It's also important to know that there have been pieces of legislation introduced to expand the enumerated characteristics under the EEOC and under Title VII to include sexual orientation and gender identity for the last 25 years. We've been trying to include those things under Title VII. The current attempt is the Equality Act, which you may have seen some press about. The Equality Act has passed the House. We don't know if it's going to pass the Senate. We don't know. But that's like a very active issue that's in the news right now. But the piece of legislation that is something that we've been trying to do for 25 years. And they've been being introduced and killed repeatedly in the legislature for all of that time. It's basically the same thing. However, between 2012 and 2017, the Equal Employment Opportunity Commission issued guidance that it believed that the people in charge of driving the bus at the EEOC believed that gender identity and sexual orientation are covered by Title VII under the sex discrimination protection. The EEOC said that it believed that discrimination on the basis of transgender status or on the basis of sexual orientation constitutes sex discrimination and is therefore covered. So there were a couple of cases between 2012 and 2017 where the EEOC actually enforced some kinds of protections against discrimination on the basis of gender identity and sexual orientation. However, in 2017, Jeff Sessions came along and we all know the rest. Now, since the Trump administration has been out of office, things are starting to look a little bit up again, but it's going to take a while to clean up the mess that they made. So the EEOC creates lawsuits. The lawsuits are interpreted under the law that is Title VII. And a few of those lawsuits in the last couple of years have gone up to the Supreme Court. The Supreme Court, when it makes a decision, it's applicable to the whole country. So there have been a couple of Supreme Court decisions recently that are relevant to the EEOC's interpretation of uh, Title VII as applicable to sexual orientation and gender identity. The Supreme Court cases are identified by the last name of the plaintiff, the person doing the suing. And so the ones that we're talking about are called Bostock, Zarda, and Harris, because those are the last names of the three people involved. The um, the decision consolidated those three cases. So it was a decision in Bostock, Zarda, and Harris together. Now, Bostock and Zarda were two plaintiffs who sued after being fired immediately after coming out as gay in the workplace. Um, they both argued that discriminating against an employee as for their sexual orientation requires an employer to intentionally treat individual employees differently because of their sex, basically saying that sexual orientation discrimination is sex discrimination because, for example, saying I'm in love with a man or I have a husband is behavior that would be protected by Title VII if it was done by a woman, but not if done by a man. And so the argument was that's actually sex discrimination. So that was Bostock and Zarda. Harris was about a trans employee of a funeral home. And after she came out as transgender, after Amy Harris Stevens came out as transgender to her employer, she was subsequently fired. And she argued that being fired on the basis of coming out as transgender is sex discrimination in the same way that being fired for being a convert is religious discrimination. Um, and I'm surprised and happy to say that even the Supreme Court in 2017 bought that argument. Justice Neil Gorsuch, of all people, wrote the decision on this, and he said, "An employer." This is a quote from Neil Gorsuch: "An employer who fires an individual merely for being gay or transgender defies the law." So that's great news. We have a piece of writing from the Supreme Court that says firing an individual for being gay or transgender defies the law under the currently written text Title VII, which does not explicitly include sexual orientation or gender identity. Now, we also have the Equality Act pending in the Senate. If it passes, which we don't know, it's a mess in there. But if it passes, then that same policy would be cemented in legislation instead of in reversible court ruling. Because at any point the court would have the ability to reverse its own ruling and decide that Title VII, as currently written, does not cover us. If it's cemented in legislation, that's a little stronger. So that's the good news. Here's the less good news. The Both the legislative arm of our advocacy and the case law arm, the stuff that happens through the Supreme Court, is running up against a strategy that is called RFRAs. That's RFRA, Religious Freedom Restoration Acts. This is a category of laws and legal strategies that use a variety of tools to exempt people, institutions, and corporations from having to comply with certain laws for what they call religious reasons. Now, in 1997, the whole category of RFRAs was held unconstitutional. But in 2014, there was a new challenge to that. It was called Hobby Lobby, and since Hobby Lobby in 2014, the unconstitutionality of the whole concept of RFRAs was struck down, and states are starting to reintroduce them because they know this court won't strike them down the way the 1997 court did. So RFRA laws prohibit the federal government or states from substantially burdening individuals' free exercise of religion unless it serves a compelling government interest. Now, that sounds pretty anodyne, but unfortunately, what it means is that any requirement that an individual does not wish to comply with of any other law, such as an anti-discrimination law, um, if they have a religious or a strongly held religious belief pretext for not wanting to comply with that, then that pretext can supersede the requirements of the law. Now, two things on this. One is that individuals here was later expanded to include corporations. So, as Hobby Lobby shows, you actually end up having the extremely goofy argument here about the religious beliefs of a corporation. So, in Hobby Lobby, there was a corporation. You may have bought um, popsicle sticks there, that is run by individuals of an evangelical Christian faith. And they believed that compliance with the provisions of the um, of Obamacare that required them to buy health insurance for their employees that covered contraceptives was a violation of the religious faith of the company, and therefore the company should be exempted from that provision of Obamacare. And the court bought this, and so this is just an example of the ways in which RIFRAs, this line of legal reasoning, allows individuals and corporations to prioritize and supersede the requirements um, of otherwise applicable statutes by reason of strongly held religious beliefs. So, in the Bostock Zarda Harris decision, Neil Gorsuch interprets Title VII as including LGBTQ people, but he does very unsubtly leave that door wide open to be undercut by a religious freedom claim. And he actually says in the decision that RFRA, Religious Freedom Restoration Acts, are a kind of super statute which displaces the normal operation of other federal laws and might supersede Title VII commands in appropriate cases. So, what he's doing here is saying, yeah, Title VII covers LGBTQ people, but if you happen to have a strongly held religious belief that gay people are evil or that trans people don't exist, and you want to fire them from your company, that's fine with me. So this is, he's basically laying out the blueprint that Hobby Lobby left behind following regarding their religious objections to the contraception coverage. Um, so he's saying if an employer wanted to argue that complying with the interpretation of Title VII in Bostock, Zarda, and Harris that requires them not to discriminate against employees on the basis of their sexual orientation or gender identity is an unacceptable infringement on that employer's religious freedom, that he would accept that argument and say, okay, Title VII doesn't apply here. Your religious freedom is more important. So basically, this decision says that Title VII prohibits employment discrimination based on the employee's gay or transgender identity for any reason that is not framed in religious terms, which I want to be clear, is not a loophole. They've been setting it up to work this way for decades. So it is meant to look really nice on the surface, but at the same time, be totally toothless. When people talk about this, they often frame it like the religion is the point and the discrimination is just the method. But it's actually the other way around. The discrimination is the point. The religion is just the costume that it wears. So, for example, right now there's a case in Texas in which an employer is arguing that being required to have insurance coverage for its employees that covers PrEP for its employees violates the employer's religious beliefs because it encourages gay behavior. In North Dakota, a court is preventing HHS and the Department of Justice from enforcing the anti-discrimination provision of the ACA of Obamacare against Catholic employers. So we're seeing the culmination of decades of work to set up sincerely held religious beliefs as a get out of jail free card against any civil rights legislation that exists. So that's the bad news. Now, what does this mean for you as a person entering the workforce? Um, the EEOC purports to protect you from facing adverse employment consequences for being an LGBTQ person. Under case law and under the expressed policy of the EEOC, Title VII covers sexual orientation and gender identity. It is supposed to protect you. Now, as we just looked at, the specter of the Religious Freedom Restoration Act hangs over this. Any Title VII case that goes before a conservative court is an opportunity for more chipping away at these protections. So, practically, we're talking about location, and we're talking about company size. So I always tell people, when you're looking uh, at possible employers, uh, if you're looking at the type of company that is all over the country that needs to avoid pissing off as many people as possible in order to keep all of its customers, which are politically and geographically diverse, you're probably going to end up with a company that's not going to be actually supportive of you as an LGBTQ person, but that's not going to actively discriminate against or fire you for that reason and isn't going to engage in a whole court case about it. Um, if you're looking at smaller, more localized employers, then again, we're talking location, location, location. Look at the courts in that state. What are they enforcing? What are they permitting? And the further this type of thing goes, as time goes on, I think the more polarization we'll see between the employment climate for queer and trans people in red states and blue states. That's something that's already the case. I think we're just going to see that gap grow more. So legally, if you are discriminated against at work, if you see any sort of negative employment consequences because of your sexual orientation or gender identity, you do have standing to seek redress. Are you sure to get it? No. Um, are there possible negative outcomes? Always. But we're doing better than we were doing 2 years ago. And 2 years ago, we were doing better than we were doing 2 years before that. And, when I was in law school, the idea that there was going to be a Supreme Court case that said that the EEOC protected me from being fired for being trans was absolutely unthinkable. And when I suggested that it might be in the future, my gender and the law professor laughed at me. So little steps are what we have in the law. And it's not it's not there to protect us, but it is a tool that we can use. And if you find that you need legal help, there are lawyers who are community members. There are organizations that are made up of community members. There are people who can help you. The thing that you learn in law school is how to navigate these extremely terrible and oppressive and violent systems for the benefit of clients. And there are now a lot of LGBTQ people in the legal field who will come with you on that journey. So I wish I had better news for you, but the good news that I have is that the state doesn't keep us safe; we keep us safe, and I think that there are going to be the opportunities for you that you need, and you have my best wishes. And please, if there's support that I can give you as a community member, um, as a person who knows a little bit about the law, please do reach out. I'm easy to find, and I wish all of you all the best.